ditching the slackers in the back.
They gave me the seat.
That's right.
We're rolling, guys.
Got to block this in case you need to block. Man, please check it, man. Check me, man. Ball spot.
Your ball spot is definitely in the picture.
Is it? Dude, look at
Practice.
you know, I noticed on his.
You might have some height on that that tripod there. Pull it up.
Yeah, I can see you now, Mr. Steve. I'm right up on you now, man.
Hey, you know what? And I can hear you now.
I know. Right up on you, man.
Welcome to the front of the classroom.
I know, right?
I told you last week that that's your permanent seat, but you didn't listen.
Yeah, you're right.
Fred, this is what we're gonna do. You're just gonna keep your head down. Okay?
Oh, it's not.
Yeah, it's still better. Well, let's back up. So remember, we were.
Oh, that's right.
We were further back.
50 feet.
50 feet, really?
That's considered segregation. Don't talk like that. We don't want to alienate you.
Listen how
You're a
y'all
good member of the community.
Oh, man. Y'all two be going at it, man. You can hear you guys.
Oh, you can.
You can hear you. Yeah. I hear you guys. I'll be at home tripping like. I was like.
He always says something.
Yeah.
Listen, I'm trying to help Forgy get subscriptions so they can start paying.
I know it's like
It's comedy. It's comedy.
Oh, it's your comedy?
It's comedy for Forgy.
I rent this shit down here. I rent suits.
No, I'm good.
Hey, man, you seen that Florida State game?
Yeah.
Yeah.
A lot of ways to win, man.
Yeah. You know, that's what happened when you're national champs, man. That tend to happen.
Get out of that cookie cutter coffee you got here.
Oh, here we go, cookie cutter. Dang. You're right. You're absolutely right. There was a time, though, we played Florida and Miami every year, and they was usually two.
We got Miami down here.
Yeah, they still here. They'll be back now. Still turning up a couple of decades off.
No, I'm Alyssa. Alyssa?
You're Alyssa. Okay, thank you. Are you on here?
Yes, I can pay.
Oh, you're right, good. I knew we had some of us on REE in this one. Okay.
She's probably teaching another class.
You so.
I like to
He's so crazy. I was waiting on that. Oh, who's gonna say it first?
I forgot, man.
I love Mike for that, though.
That's crazy.
All right, folks, we gotta go.
All right, that's right. I knew that was coming.
That was the wrong one. Too many people.
I knew it was coming.
Mike, you know you're wrong.
Oh, they had a nice car show over there, man. You guys should have checked it out.
Say what?
They have a car show. It's right across the street from the museum.
Here, I'm about to come back.
Right now going on?
Yeah, it's over there.
You know, I heard a bunch of noise coming in this morning, and
Really
like somebody
nice.
in a loudspeaker, and I couldn't tell where it was.
Really nice cars.
You know,
Really nice cars.
muscle cars and stuff like
Yeah,
that.
yeah.
Very cool.
Yeah, I had to take, they had that 69 Continental, the suicide. Oh, I love that car, man.
Sounds very southern of you, Frederick.
I'm a car guy. We're school.
All right, folks, we're going to start. Got to do it. And I want to make a comment overall. I feel badly that it seems like we're having to rush, and I hate that. And I hate to cut off anybody's comments or questions. I'm going to be stunned if we're able to finish the book. I doubt it, but it's my job to try. And that's why I keep fighting to see if I can keep us moving, although I don't like to, and a lot of these things, any number of things in that contract, I would like to have spent 15 minutes each on. We just can't do it. So if you have questions, for God's sake, ask me later. Ask me after the test, ask me another time, send me an email. But our time in here, unfortunately, is limited. Chapter 12 is on real estate brokerage. We have 6 or 7 by my count licensed sales associates in the class, at least 1 licensed broker. those of you who are so licensed, I hope you'll speak up. Partly for that reason, I'm going to go as fast as I can through this chapter, because a lot of people know this stuff already, and an awful lot of this doesn't have anything to do with you dealing with real estate brokers. It's nice stuff to understand the basic law of principal and agent and stuff like that, and I want to say that agency is another whole course in law school, and it's all off into implied authority and what agents can do and can't do and all that, and it's just way beyond where I think we need to be. And in addition, has absolutely nothing to do with real estate. So I'm going to try to hit what I think are the high points and see if we can cover a couple of chapters before this afternoon. Agency in general is where one party authorizes another to act on his behalf. The principal authorizes an agent to deal with third parties, and that's called agency. And most particularly, the agents that we're trying to deal with here are brokers. And that's real estate brokers. And a real estate broker is defined as an agent, it's a type of agent, who for a fee brings parties together to negotiate involving the sale or exchange of real estate. I think everybody knows that. And you may not be aware, and this is again a concept for another whole course, but that a real estate broker is an independent contractor. And all that means really is that, in our context, that a real estate broker is not an employee of the seller. And we're talking in all these cases, until I tell you we're changing gears, as a broker being an agent of the seller. We're talking about a seller hiring a real estate broker to sell a piece of property. That's not always the case, but we're going to be in that context until we shift. When a seller of real estate hires a broker to sell a piece of property, that's called a listing, or a listing agreement. But most people refer to it loosely as a listing. But it's a contract, like other contracts we talked about. It's an agreement. And there are three basic types of listings. And fortunately, for a change, the three names make sense. They explain, you think about the terms, and I'm going to do them in a different order than the book did, because I think they make sense arranged differently. The first one, I think, should be called an open listing. And an open listing is where a seller signs an agreement with a broker that says, I'll pay you commission if you find me a buyer, and only if you find me a buyer. But I'm not agreeing that you're the only broker I'm hiring. It's an open listing. Seller's basically saying, seller might sign 10 of these. with 10 different brokers that say, I'll pay you a commission if you bring me a buyer. It's an open listing. Now, the next more restrictive is called an exclusive agency. And there the seller says, broker, I'll pay you a commission if you get me a buyer, but I reserve the right to sell my property myself and not pay you a commission. But back to the name making sense, you are the exclusive agent, though, that I will hire. I won't hire any other brokers. That, of course, gives the broker an incentive to work harder, knowing that he's the only realtor that's going to have the opportunity to sell this property, and the only other person he has to worry about is the seller selling it himself. Exclusive agency, you're the exclusive agency. Now, the next and last and tightest for the broker and most attractive to the broker is the exclusive right to sell. And what that means is, yeah, you're the only broker I hire, and I'll pay you a commission if the property is sold during the term of this agreement, no matter what, even if I sell it myself. You have the exclusive right to sell this property, and that includes me, exclusive of me, the seller. Okay, those are the three different types of listing agreements that an owner can sign up with a broker. Now, the materials introduced now, a concept that we all kind of take for granted. And it's called the multiple listing service. And I disagree a little bit with the description. The materials call it, materials state that the brokers are sharing all their exclusive listing agreements. And I don't think that's really what they're doing. They're publicizing all of their agreements. They're getting the word out, and they're agreeing to share commissions with another broker who sells it. But they're not agreeing that other brokers have the listing. Under multiple listing service, I'm sure most of you know how this works. All the homes that are available for sale by all of the member agencies on all of their multiple listings are all together in a computer network, and everybody can go look at them all. But still, as to each of those homes, there is always a listing broker, and he remains the listing broker. And what he's saying is, all of you other realtors, if you want to come sell the house that I have listed, I'll share with you the commission under my listing agreement. That's called MLS. And as to residential real estate, it's pretty predominant. It's pretty rare to have a listing that's not there because people don't find out about it. How are you going to advertise it? How are you going to get the word around? Okay. The materials go into, at length, authority, and I'm not going to get into that. They talk about implied authority and express authority, and those are all, again, all these concepts of agency law that are pretty complicated and aren't really relevant. The important thing to realize is that we're talking about the broker's authority here to act on behalf of the seller. Realize, if you would, and I don't think you'll ever encounter this, excuse me, most real estate brokers' agreements do not authorize a seller to have his name signed on the contract by the broker. The seller's signature on the contract should be signed by the seller, not by the broker. That's all we're getting at. Generally, in the law of agency, when you hire an agent, you authorize people to sign stuff for you. But in a real estate listing agreement, you are not authorizing a real estate broker to sign a contract. Now, we're talking about the seller's broker, and the broker has certain duties to a seller. And the first one is characterized as good faith and loyalty. And the definition is that the broker do everything to advance the interest of the principal, even at the expense of the broker. What they're talking about is broker doing what's best for the seller, not just what's best for the broker. And the first and foremost aspect of that duty of good faith and loyalty is the duty of full disclosure. And that's important in a couple of respects. It's important that the seller be advised of everything that's going on as to his piece of property by the broker. And when you're a buyer, and when you're dealing with the seller's broker, often as a buyer, you may not have your own broker. You may see a sign on a piece of property with a listing broker, and you may call the listing broker and go deal with the listing broker. And pretty soon you feel like he's your buddy, and we're getting along great, and he's your friend. Remember, he is the agent of the seller. He is duty bound to tell the seller everything that you tell him. When you say to that broker, I'm offering him $100,000, but I'll probably go to 125. You're going to 125. He's going to go right back to the seller and tell him that. And that's what's going to happen. And he's obligated to do that. And you need to understand that. But that's who that broker works for. Although that broker, as we just said, works for the seller and has all these obligations of good faith and full disclosure to his client, the seller, the buyer that he may be dealing with, he still has a few duties to a buyer. And we're going to talk about those greatly in the next chapter. And that's where we get into misrepresentation and fraud. What I'm getting at is when the seller's broker is dealing with the buyer and the buyer asks questions to the broker has to answer truthfully. Now, he doesn't have to answer questions like, what will a seller take and what's the seller's best price, but he can't misrepresent things about the piece of property. He can't hide behind, gee, I just worked for the seller, I didn't have any responsibility to that guy. The courts will hold a broker accountable, even though that's not their client. Okay, up till now we've been talking about the seller's broker, which is the listing broker. with whom the seller has contracted to sell my piece of property. It is possible, but way less frequent, to have a broker work just for a buyer. Buyers can contract with a broker to find a piece of property for them. And then it doesn't necessarily turn on who's paying that broker, though. Sometimes the buyer's agreeing to pay the broker commission. And sometimes the broker is being told, go share that listing commission with the listing broker. Find me a house, but share the commission, but you're my broker, you're working for me. I should have said at the beginning of this, there are other ways that a broker can be employed other than by a seller only. This was the first one. Up until then, all the broker stuff and the concepts of listing and agency and all that, that's all about the seller broker. Now we're going to shift to other ways a broker can be hired and not represent just a seller. The first one is a buyer's broker. The second one is something called dual agency. And this is kind of a strange concept, but that's where a broker in a deal represents both parties. And the brokers have both parties sign a disclosure form where each one says, yeah, I know you work for me and the other guy too. And that's dual agency. And there's not much to say about it. It is what it is. And then thirdly, there's something called a transaction broker. And that's supposed to be a broker with less responsibility to either of the parties. And less of these fiduciary good faith obligations. Their sole job is to get a deal closed, but the standards to which they're held are less. And again, to me, that's not worthy of going into, except to understand there is such a thing. Now we want to talk about the broker's commission, because there are lots of disputes over realtors' commissions. The courthouse is clogged with suits over real estate commission flaps. Thank God, a lot of them get settled at the administrative level by FREC. But there are tons of lawsuits in the courthouse of brokers suing for commission. And the courts have said there are two questions to determine when a broker is entitled to a commission. Clearly, the first one is, has the broker done the job he was hired to do? But secondly, the courts say, at what point does that job entitle him to a commission? And without question, all courts all over the country agree and use this kind of self-defining term, for lack of a better word, procuring cause. The buzzword for a realtor is procuring cause. Was the realtor the procuring cause of the sale? The primary and proximate cause of the sale is what some courts say. The point is, would the sale have happened but for the services of the broker? And the biggest definition working into that procuring cause is, has the broker produced a buyer who is ready, willing, and able to close. And you hear that constantly. And that means, is that buyer capable of purchasing the property? And if the buyer meets those tests imposed by the court to determine whether the buyer was capable, then most states, including Florida, agree that the broker at that point has earned his commission. Now, I want you to realize that does not necessarily mean there was a closing. And that's where this gets real sticky. If you're a seller and you sign a listing agreement and you provide in there that, Mr. Broker, if you will bring me a ready, willing, and able, capable buyer, capable of buying my property for $100,000, at that point, when that broker produces that buyer who's willing to close, the broker has earned his commission. Traditionally, payment of the commission is put off until closing. And the biggest reason for that is because that's when there's a pot of money to pay the broker with. But that's not the test of when a broker has earned his commission. I want you to realize also that if you sign a listing agreement with a broker and you say, bring me a buyer who's ready, willing, and able, financially capable of closing, and the broker does it, and you don't sign the sales contract for whatever reason, you can be sued for commission. Even if you never had a deal. You never signed a contract to sell. Or you signed a contract to sell and it didn't close. If the broker has done his job of producing a ready, willing, and able buyer, then you're obligated for commission. Even though normally the commission payment is deferred until closing. That doesn't mean closing is conditioned, the commission is conditioned upon closing. Now know, if you will, sophisticated sellers put that provision in their documents. If and only if there is a successful closing. Because they don't want to be in a position of having to pay a commission unless they had a sale and got their pot of gold. But those are not the tests in brokerage law. Okay. We've talked up until now about real estate brokers. Of course, I want you to realize, there's those of you who are not so licensed, and many people are, that there's another capacity called a real estate sales associate. And sales associates are licensed in Florida, just like brokers are. But sales associates cannot sign listing agreements with sellers by law. Only a licensed broker can sign a listing agreement with a seller. A sales associate works for a broker and, as the term goes, hangs his license with a broker because he can only work under a broker's supervision. But he does have a state license. Now, I have one last concept I want to discuss, and then I'm pretty well through with this chapter, but to me it's an important concept. But up until that point, does anybody have any question about the structure and what we're talking about here? Seller signing the contract with a listing agreement with a broker, hiring a broker, sales associates work for the broker. There may be a buyer's broker, there's often going to be a second broker dealing but sharing the commission. Now, okay. There's a big area in the law big issue in the law of the unauthorized and unlicensed practice of law by real estate brokers. And I want you to know it's a third-degree felony in Florida, punishable by up to 5 years in prison. If the courts decide that a real estate broker or anyone without a law license has practiced law, third-degree felony, 5 years in prison. The reason it's important here is because, frankly, real estate brokers are involved in deals all the time where they're asked for their advice. And they're asked for advice that, frankly, is sometimes legal advice. And they're called upon to draft documents. And some of those documents are legal documents. So we've got a huge body of law in Florida on what Florida calls the unlicensed practice of law. Our text calls the unauthorized practice of law, same thing. Our Florida Supreme Court has said that there's a two-pronged test to determine what is the unlicensed practice of law. And the first is the activity that we're talking about, in fact, practicing law? Now that sounds kind of silly, but the definition is not easy to come by. But is it the practice of law? And then secondly, even if it is the practice of law, is it authorized? Because there are various small, narrow areas of the law where the courts have said, this is the practice of law, but there's certain people that will do certain aspects of it without a law license. So, as to the first issue of what is the practice of law, unfortunately, it's really vague, and I'm going to read to you, don't try to write this down, this subjective concept of what is practicing law as far as the court's concerned, such that you could be held criminally liable for it. The court says, if the giving of the advice and the performance of the services affect important rights of a person under law, and if the reasonable protection of the rights and property of those persons who are being advised requires that the persons giving such advice possess legal skill and a knowledge of the law greater than that possessed by the average citizen, then the advice or the services do constitute the practice of law. Not only is that a mouthful, but it's really hard to figure out. So, but that's the test in Florida. It's been the test since 1962, and the courts have never come up with a better definition. The one thing that they've said is that the single most important concern is the protection of the public from incompetent, unethical, and irresponsible representation. That doesn't help much either, to figure out what is it. So what we have is a series of cases where the court, in lots of different areas, has said that is practice of law and that is not practice of law. And I know that's not very helpful. But for example, like accountants, or the courts have said what accountants may do. Licensed, certified public accountants. They said in 1967, they said what title companies may do. And they've clearly said that some of what title companies are doing is practicing law. But they can do it because they're preparing legal instruments. They can do it if they're writing title insurance. If the instrument that they call for is a condition of their insuring the title, then they're authorized to do it. Throughout, going way back though, to 1950, the Supreme Court did say that drafting sales contracts is practicing law. Drafting a sales contract is practicing law. However, the court has said it's authorized if it's done by a licensed realtor. So that two-pronged test of is it practicing law? Yes. But is it authorized? Yes. So real estate brokers, that's what we're talking about, are authorized to draft sales contracts even though it is the practice of law. Now, in different cases of things that a realtor could stumble into doing that relate to real estate, cases from the 70s all the way through the 90s, the courts have said that preparing warranty deeds, preparing quitclaim deeds, preparing land trusts, preparing mortgages, preparing leases, all of those are the practice of law. And all of those are prohibited for real estate brokers to do. However, just like the court made an exception for realtors to prepare sales contracts, the Supreme Court has approved 3 forms of leases. And one of them is the lease form that we looked at when we did leases. That was that residential condo unit form with fill in the blanks. As to those 3 leases, the Supreme Court has said realtors are allowed to fill in the blanks in these 3 Supreme Court approved forms, filling in information supplied by their clients. They're not allowed to decide what goes in the blanks, but they're allowed to sit there and ask the landlord or the tenant, what do you want me to put in this blank for rent? What do you want me to put in here for term? Realtors can do that. That's really all I have on this chapter. I wanted to make those important points about the practice of law because, as I said, and some of you missed coming in, at least half of the class has a real estate license. Most people don't realize that it's a felony, and it's the bar, the Florida bar, that starts these cases. The Florida bar gets upset when lawyers see unlicensed people, as far as they're concerned, practicing law, and leans on the state's attorney. The state's attorney files criminal charges and does the prosecutions. And these are the tests that we have. Okay, I'm going to quit on that chapter unless anybody has anything else. We could spend days on real estate brokers, but I'd rather we did. Okay, I want to skip on then to go on now to chapter 13, which I think is hugely important. And I want to see if we can get this finished, and maybe even more before our exam. Chapter 13 is fraud. And this is real important. Real important for you folks, whether you are or aren't realtors, when you're dealing with real estate and you're dealing with other parties trying to sell real estate, selling your own, or selling as a realtor. You need to understand what fraud is, and you need to understand the case that we're going to talk about at the end of this that extends way beyond fraud. And it's huge, and we're gonna spend most of our time talking about that one case, because it totally changed the law in the state of Florida. But to go back to the starting point here, remember that in history, law has always said caveat emptor. And we talked about that once or twice before, I think. Caveat emptor is Latin for let the buyer beware. And that's always been the law of buyer, whatever you're buying, unless the seller made some warranties, you're on your own. Check it out, make your own determination. It's at your risk. If you don't like it, don't buy it. But don't buy it just assuming everything is okay, because the law says let the buyer beware. Now, with some very limited exceptions, that's still the law in commercial real estate. However, in residential real estate, the pendulum is swinging just the other way. Pendulum is swinging in favor of buyers in residential real estate and saying buyers are unsophisticated and buyers can get screwed, and let's look out for them and let's protect them and make sure that people don't deceive them and defraud them and mislead them and conceal things. And almost daily, the law swings further and further in that direction. So, since the law is going that direction, we need to be doubly careful about fraud. And fraud, which is the same thing as misrepresentation. Fraud is a deceptive act or statement, usually a statement, made by one person in an attempt to gain an unfair advantage over another. Now, traditionally there are three elements of fraud. And at the end of this, I'm going to tell you that in Florida there are four. But those four are really the same three said differently. But our court says there are four, but they don't cover any additional concepts other than these. The first is intentional. In order to be fraud, or to be a fraudulent misrepresentation, it has to be deliberate. The seller, usually, had to intend to deceive the buyer in order to, as the definition says, gain an unfair advantage over the buyer. And intent, as we talk about in criminal law, is all about what's in the mind of the guilty. It can be hard to prove. And intent can even be implied if someone makes a statement with total disregard to knowing whether it was true or false, without caring whether or not it's true or false. I'm sure you've heard the term of reckless disregard. Ever watch Law and Order? It's on every 2 weeks or so. They say somebody did this with reckless disregard, or that reckless disregard.
Every day, man.
Yeah, reckless disregard is not giving a damn whether it's true or not. But making the statement with the intent for someone else to rely on it, and not caring whether or not it's true or false. Of course, in all the cases we're talking about, it's going to turn out to be false. If it was true, there's no problem. Now, there's one type of statement, though, that is intentional, but that the courts say this is not fraud, and it's called puffing. are bragging, or the text talks about it as dealer's talk. I don't know the term dealer's talk. But it's using statements where you're trying to induce a buyer to buy, but the courts treat them like opinions and say, these are the type of things you should have known was just an opinion, and you shouldn't have relied on this. Like, this is the best house in Fort Lauderdale. Come on, you know. If you bought a house because of that, then maybe you don't have capacity to contract. You know, or this is the best deal you'll ever have, or, you know. Those are probably not true, and they're intentional, but the court says that's puffing. Buyer was not entitled to rely on it, and that's not fraud.
Those are your go-to lines, right, Fred?
You know, I think you
Use it all the time.
Silence can be construed as fraud under some limited circumstances. And active concealment can definitely be fraud. Actively concealing, covering up a defect can be fraud. I want to tell you a story of what I consider to be a classic example, and unfortunately I know all too well how and where it happened. But I mean, you could like painting over things and stuff like that in order that people can't see them. I mean, actively concealing. But I want to tell you a story of one that is just so egregious. In the Keys. Don't know if you ever heard of conch houses in the Keys, but you know, in the 30s there were a couple of hurricanes that washed over the Keys completely. I mean, washed out everything, washed out Flagler's Railroad, washed out all of the homes, knocked down all the buildings. And of course that meant that all the land in the Keys was covered in salt and salt water, which sunk down into the ground. Right after these hurricanes, local people decided to build homes that they said will never again be knocked down by a hurricane. And they poured 18-inch thick solid concrete walls with steel rebar in the middle of the walls, thinking like a bunker, next hurricane, have at it, you're not going to knock this one down. And they were called conch houses. And a lot of builders went around the Keys building these conch houses with these 18-inch thick solid poured walls. Unfortunately, they used local sand to make the concrete. The local sand was full of salt water from the hurricane that had just come over. And so when they mixed the concrete with the local sand, that means we had salt inside these 18-inch thick solid walls. Salt wrapping all around the steel rebars that are going up in the middle of the walls. And when steel rusts, steel expands, and it starts breaking up your walls. And although these homes have, you know, you couldn't knock them down with a bulldozer, what was happening though was that the walls were starting to burst from inside. And when that started happening, years later in the 60s and 70s, and people were trying to sell these homes, wherever it was cracking like that from the expanding steel, people would go around with plaster and patch them up, and then paint them up, and then try to sell their house. And of course, an unsuspecting buyer comes along, and his house looks gorgeous, and everybody tells them this is one of the conch houses, 18-inch thick walls, this is never coming down, don't worry about it. And the example I was involved in fact, went into the house and removed electric switch plates from the walls. And there was seaweed in there. And that was cool, because that was a proof that, see, in Hurricane Donna and other hurricanes where the water was up here above the mantle, the house filled up with water, but see, these houses are still here. See, there's even seaweed inside. That shows you how tough this house is, you know? But what they don't tell you is, but over the next couple of years, your walls are going to explode out. And so sellers, in any number of cases, plastered up these walls, painted them, and sold the houses, and didn't disclose. Courts started holding that was active fraud. Not so much that you made a statement you intended somebody to rely on, you took an action you intended somebody to rely on. You didn't say anything, silence, but you actively concealed something, and that's fraud. So it can happen without a statement or a puffing. Yes, ma'am.
No, you said to wait till the end, it's fine.
I'm sorry?
You said to wait with the questions till the end, so go ahead.
All right. Okay, now, there are two more things. I told you there are three requirements of fraud. The first one is the court says it has to be intentional. The second one is the party aggrieved, the buyer, has to have relied on it. Actually relied upon the fraudulent statement and acted upon it. And of course, the reliance has to be justified. In other words, not this is the best house in town and I relied on it, so I bought it. But I mean, a statement that you relied upon and you were justified in relying upon. That's the second element to prove up fraud. And the third element, the statement has to be material. And that's a tough one. Material means material, important, big, significant. It has to be hugely important. But a lot of cases are gray areas and are hard to define. That normally is a question that a jury decides. Was it or wasn't it important? The other cases, often the court can determine whether or not it was intentional and whether or not there was reliance. But material is a lot more subjective. Now, I'm going to tell you how Florida rephrases those three things into four things. But you don't need to try to memorize these. I just want you to hear that in Florida, there are four elements of fraud. Florida calls it fraudulent misrepresentation. And it says as follows, number one, a false statement concerning a material fact. So we got material again. Secondly, the representor's knowledge that the representation was false. That means it was intentional, like we talked about. Thirdly, an intention that the representation induce another to act on it. That's intention and reliance. And four, injury. Injury to the party who relied on the representation. So Florida calls it a fourfold test, but you're getting at the same three things. If you satisfy the three we talked about before, which are the general law around the country, you're going to have covered Florida's four tests. Okay. If you have fraud, the question is, what are the remedies? Mainly, the remedy is damages. There is no question that if it's possible you can rescind a contract, but often the fraud arises so far down the road that rescission is impossible. You remember we talked about rescission, let's undo the deal, let's pretend we never even sold this house and put them both back and say, often it's just not a feasible remedy because it arises years after a closing. But in a situation we're going to talk about, not necessarily. So rescission is theoretically available, but the most important thing is damages. And here again, we touched on this a little bit before, but I want to touch on the two types of damages. Number one, actual compensatory damages. Those are damages that you can prove. What did it cost me to fix it? How much of a loss did I suffer as a result of the fraud? But secondly, and hugely important here, because the courts consider fraud to be such a do-badder thing, that you've done something really bad here, there's a great possibility for punitive damages. And punitive damages are when the court decides that the fraudster's conduct was so, the courts use all different words, egregious, oppressive, committed with ill will, with malice, with spite, where you really tried to hurt somebody. The courts say we're going to impose punitive damages. Punitive is like the word punishment. And they are damages calculated to punish the defendant for his bad conduct. And know, if you will, like the punitive damages you hear about in cigarette tobacco cases. Punitive damages are calculated in an amount sufficient to punish the defendant. What that means is getting a $1,000 punitive damage judgment against R.J. Reynolds doesn't cut it. And that's why the courts award a $300 million punitive damage award against R.J. Reynolds, or against Ford Motor Company, or against Firestone Tire Company. If it's a big company and you want to punish them, saying, okay, you owe an extra $1,000 because you were bad, there's no punishment there. And that's the scary thing about punitive damages, in that they are calculated in an amount sufficient to punish the wrongdoer. And they're also called exemplary damages. Exemplary is to set an example, to be a deterrent. Just like supposedly the death penalty is a deterrent, that other people, you won't commit murder because it's a deterrent, you saw somebody punished with capital punishment. Theoretically, if you see somebody hung out to dry for fraud, maybe you'll think twice before you commit fraud, and it'll teach you the lesson, teach others the lesson not to commit fraud. Exemplary damages. But punitive damages is the most common term. We got two kinds of damages: your actual damages that you can prove, and punitive damages of let's punish the defendant for being really bad, and those are the big numbers. Now, the materials then talk about waiver, and that's kind of silly and kind of obvious. If you waive the fraud and don't act in reliance on it, will eliminate actionable fraud. I'm surprised we even had to bring that up. But the one small portion of that I want you to realize is, and this is where the materials bring it up, is exculpatory provisions in contracts that say, I, the seller, am not liable for nothing, no matter what I do, no matter what I say. The courts will not uphold. Their void is against public policy. They actually use the word waiver in there, where they say buyer waives any claim. Well, we're talking here about a waiver at the buyer's choice. The buyer in our example chose to waive it. and then obviously there's nothing actionable. Now, I want to tell you about we're going to get through this and then we're going to do the exam. I want to get through this case, and if it runs over a couple of minutes, by God, then we'll run over a couple of minutes for the exam because this is hugely important. I want to tell you about the case of Johnson v. Davis in Florida. And I want you to know about the case. And I want you to be able to know that name of Johnson v. Davis because it's huge. It's a landmark case in Florida, restricting caveat emptor. And it's cited by courts all over the country as being good law. And I want to tell you a couple of facts, and I want to read you a couple of things the court said. Because this is about fraud, but it's about fraud in a way that you might not think about. Mr. and Mrs. Johnson agreed to sell a house to Mr. and Mrs. Davis. $310,000, the house is 3 years old, no big deal. The importance are, Davis has put down a $5,000 deposit. You don't need to know this stuff. I just want to talk to you about, I want you to understand the facts, but then I do want you to know the punchline. But this is how we get there. $5,000 deposit, $26,000 deposit is the second deposit, then we're supposed to go to closing. And the contract contained a prevailing party attorney's fee clause. Now, here's the Florida Supreme Court speaking, and this case again is cited all over the country as great law. Before the Davises made the additional $26,000 deposit payment, Mrs. Davis noticed some buckling and peeling plaster around the corner of a window frame in the family room. And she noticed stains on the ceiling in the family room and on the kitchen, and in the kitchen of the home. Upon inquiring, Mrs. Davis was told by Mr. Johnson that the window had had a minor problem, but it had long since been corrected and there was no further problem. And that the stains were just wallpaper glue and the result of some ceiling beams that had been removed. And the court says there is some disagreement as to what else Mr. Johnson might have said, where he said there'd never been any problems with the roof, but that's not real clear. The Davises thereafter paid the remainder of their deposit, and the Johnsons vacated the home. Several days later, following a heavy rain, Mrs. Davis entered the home and discovered water gushing in around the window frame and the ceiling in the family room and the light fixtures and the glass doors and the stove in the kitchen. Water gushing from all these things. Two roofers hired by the Johnsons brokers concluded that for under $1,000 they could fix certain leaks in the roof and that would make the roof watertight. Three roofers hired by the Davises found the roof was inherently defective, that any repairs would be only temporary because the roof was slipping, and that only a new $15,000 roof could be watertight. So, the Davises, the buyers, filed a complaint alleging breach of contract, fraud, and misrepresentation. Sought rescission of the contract and return of their deposit. The Johnsons counterclaimed, seeking the deposit as liquidated damages. I'm doing a lot of these because this is all stuff we've talked about and it's all really relevant to what's going on here in this case. The trial court. The trial court entered its final judgment, making no findings of fact, but awarded to the Davises their $26,000 additional deposit back and awarded to the Johnsons the first $5,000 deposit, and said each party was to bear its own attorney's fees. Both parties appealed. This judgment of the trial court was so stupid that both sides were unhappy. So Johnson's appealed and Davis's cross-appealed. The 3rd District Court in Miami found for the Davises, the buyers, affirming the trial court's judgment that they get their $26,000 back, and reversing the award of the $5,000 they gave to the seller, and awarding to the Davises their court costs and attorney's fees. And the Supreme Court remanded, sent the case back to the trial court, and said, do what we just told you. Now that's the facts. But I want you to hear the law, and the statement of the law made by the court. This is not it yet. It is the background. Here's what the court does. The court goes on and talks about caveat emptor at length. You know, history of the law is a buyer beware. And that all of the problems it can cause. And the court cites case after case of how buyers get screwed and how distasteful the courts find it to be. And after reviewing all of these different cases where defective roofs and bad swimming pools and all these things, and the courts in all these cases, appellate courts, even the Supreme Court previously, has said there is no duty of a seller to advise buyers of problems with a house. The court says, this is not the holding yet, these unappetizing cases are not in tune with the times and do not conform to current notions of justice, equity, and fair dealing. One should not be able to stand behind the impervious shield of caveat emptor and take advantage of another's ignorance. Our courts have taken great strides since the days when judicial emphasis was on rigid rules and ancient precedents. Modern concepts of justice and fair dealing have given courts the opportunity and latitude to change legal precepts in order to conform to society's needs. Thus, the tendency of the more recent cases has been to restrict rather than to extend the doctrine of caveat emptor. The law appears to be working towards the ultimate conclusion that full disclosure of all material facts must be made whenever elementary fair conduct demands it. And then the court goes through cases all over the country in the other states and what other states have done. Starting with California, which has always been the most progressive courts anywhere in the country. And it cites cases in California, Illinois, Nebraska, West Virginia, New Jersey, Louisiana, Colorado. And it ends with this. This is the punchline, and this is what you need to know. We hold, and we're going to go back and discuss the important words in this. We hold that where the seller of a home knows of facts materially affecting the value of the property, which are not readily observable and are not known to the buyer, the seller is under a duty to disclose them to the buyer. This is equally applicable to all forms of real property, new and used. That's the holding in the case. That's a huge 180-degree novel change in the law in Florida. And that's the law in Florida today. And I want to just make a couple of comments about what's happened since then, but I want to discuss that holding again. Remember, we talked about what courts do is they have holdings. We hold, that's where that word comes from. We hold them. It means we decide, we decree, this is the law. That where the seller of a home, remember this is a home, and this still has not been expanded to commercial real estate. Where the seller of a home knows of facts materially affecting the value. You remember we talked about material, which are not readily observable and which are not known to the buyer. The seller is under a duty to disclose those facts to the buyer. The same court in subsequent cases has gone on to say, even though the falsity could have been ascertained if investigated, even though the Davises had the right under their sales contract to have a roof inspection, well prior to that, if the seller knows of a defect, it's not obvious, you can't tell walking around the house what condition the roof's in, you're obligated to disclose. They said in another case, there is no requirement of fraud or negligence. There is no need for proof of the seller's intent. The forgetful seller is just as liable as the fraudster. If you forget to tell somebody this, you're just as liable as if you intentionally didn't tell them. Now, the court did find in Johnson v. Davis that there was fraud. But they went on to say, even without fraud, under these facts you are obligated to tell them. They found there was fraud because of the things that the seller told them. But they're saying even if the seller hadn't made those comments, when these conditions exist, you were obligated to disclose these things to the buyer. In 1990, in Dade County, the court ruled even the as-is FAR bar sales contract, we talked about the as-is contract, there is a residential as-is form. We talked about the as-is commercial contract today, but there's a residential as-is form. The court said that doesn't work. As to these matters, what the court has covered in Johnson v. Davis. If it materially affects the value, if it's not observable, the buyer doesn't know about it, seller's got to tell them, I don't care what, doesn't care what it says as is, doesn't matter. But the court has consistently said that we're not going to apply this Johnson v. Davis rule to commercial property. The problem is, so what's commercial property? The triplex commercial property? Is a 6-unit apartment building commercial property? Maybe the buyer's going to live in one of the units? Some of these is a little bit gray. I mean, clearly the court's saying it doesn't apply to a shopping center. And it does apply to a single-family home. It's the in-betweeners that we're left to try to figure out. So, that's Johnson v. Davis. It's hugely important. And it's created in Florida a whole new cause of action where people don't even sue people anymore for fraud. They sue them for, quote, Johnson v. Davis non-disclosure. That's what they put right in their complaint now. Your Honor, this is a Johnson v. Davis non-disclosure case. Not for what the seller said, but for what the seller didn't say. And that's it.
Okay.
Yes, sir.
One quick question. How can you prove that, how would you prove the intent of the seller? Like, what if they didn't know, honestly didn't know?
Well, yeah, that's a difficult burden. If you can find that the seller had had a bunch of roof repairs before, then clearly he knows there's a problem with the roof. It's a factual test. I mean, you prove intent by outside factors trying to show that clearly he was aware of it. And if he's aware of it, then there is intent.
Yeah.
But what we said here was there's not even required the intent to deceive. There's just plain old the obligation to disclose if the seller knows about it. Now, you may have to prove the seller knew about it.
Okay, who that fault?
Okay, that's the same. There's one thing proving the seller knew about it. The intent to defraud somebody is even a tougher thing. You know, you first got to prove the seller knew. Of course, the seller couldn't be required to disclose he had a bad roof if he didn't know he had a bad roof. Interestingly, in this case, the roof was slipping, and I've heard of that from a roofer. I was astonished watching a roofer putting on roof tiles, and through these beautiful Spanish roof tiles, driving nails through the tiles to lock the tiles to the roof. And it was for exactly the problem in this case. What happened was tiles started slipping and sliding down the roof. The weight of all of the tiles would make the roof just slip and slide, and that's what was happening in this case. The tiles were not nailed down. And of course, you know, when they drive nails through these tiles, it cracks tiles, it puts holes in the tar and the membrane, and that creates a leak itself. But the roofing code now requires it for a problem just like this, where a roof is actually slipping off, sliding down off the house. And that's what was the case here. But until it started to move, And until it started to break up the tiles and everything, standing outside looking at the roof, you never
might
know.
know, right.
You know? And that's what the court said, not observable, not readily observable. But even though, the interesting thing is even though they had a right to have a roof inspection, seller, and you don't get to hide behind and say, well, I gave you the right to a roof inspection, why the hell didn't you go have one and then I wouldn't be in this position?
Yeah.
The court is saying, no, you're obligated to tell me. Yes, ma'am.
Did this ruling prompt agents to start giving their sellers the real property disclosure, that 6-piece disclosure they have to fill out about the property? Was it because of this ruling?
To be honest with you, is that required in Florida now? I didn't know that it is, because I don't do any residential work. Is that?
Yeah, most sellers have a property
Okay.
disclosure they include and give to buyers.
I have seen them in other states. I am not familiar with what the law is in Florida as to how that works and how that discharges an obligation. I know that in a lot of jurisdictions, the seller has to fill that out and you have to give a copy to the buyer.
Right.
The question is that adequate disclosure? To answer your question, I don't know.
Okay.
I don't know, I haven't seen any cases that say whether or not it is. Clearly, that form was designed after this case to try to eliminate that type of liability. But whether that type of disclosure alone is enough to eliminate a seller's responsibility and say, see, I told you there, I don't know.
And what year was this case?
I'm sorry?
About what year was this?
This was 1985.
85.
1985. Okay, guys, we're gonna do the exam.
All right, man.
Once again, closed books, please put it all away if you would. Having said that, though, I need to say one more thing.
Oh,
I need to give you your assignment for next week because when you're finished with your test, you're going to go, and I'm not going to get a chance to talk to everybody again. We didn't make it through we made it through chapter 13. We didn't make it through 14. I'm sorry, 14 we skipped. And I need to talk to, by the way, somebody has an 8th edition of the book. Who was that? Several?
Johnny.
Okay. The chapter 14 I told you to skip in the 8th edition is not the chapter I want you to skip. They changed chapters in there. I found that out like yesterday to my astonishment. The chapter we were trying to skip was chapter 14 on escrow closings. In the 8th edition of the book, they moved that to chapter 20. So skip, if you have the 8th edition, skip chapter 20. But chapter 14 is the chapter 15 that I want to cover next in the 7th edition. In other words, we need to chat. We're going to start with involuntary liens next time, which is the one chapter assigned last time that we haven't covered yet. That's chapter 15 of the 7th edition. I guess that's chapter 14 of the 8th edition.
Right.
And we want to get through chapter 20.
Man, I got 6.
And that's going to cover a lot of material, but we got to do it. So I'd like you to read forward through chapter 20. And that's deeds, legal descriptions. I'm going to send you some deeds with legal descriptions in them. We're going to look at forms of deeds and legal descriptions. We're going to talk about estates. We're going to talk about recording. And we're going to talk about closing statements. And I'm going to send you a closing statement, and we're going to go through that. Yes?
What chapter is our final going to start on?
I'm sorry?
What chapter will our final start on? Is it going to be points and A's?
Final will go all the way back.
Oh, well.
The final will be the whole course.
Okay.
Yeah.
Boy, you the man.
It's not just from here forward.
Open book.
Can you tell us what you're gonna skip on those chapters, like or you just usually like go like this not important or highlights?
Will I do what? I'm sorry, will I tell you what I'm going to skip? Is that what you said?
Sections in the chapter.
That's what she was.
It is my intention to get through the whole book, but I don't think we're going to make it. But that doesn't mean that you're not responsible for it. It's my job to teach all the chapters that are in the book, and I'm going to try.
Yeah, but within the chapters, sometimes you say. This is
Oh,
very
absolutely.
important.
as I've been doing for 3 weeks. I've been saying, you're not responsible for this, you're not responsible for that. I'll continue to do that, and you will not be tested on anything that you're not responsible for. Okay.
No. Throwing you no softballs. Sound thing.
You get Is Daryl Ballou here today? Yeah. Yes, Daryl, okay, great. You're the only guy who didn't get on the roll. I'll bring it to you. Thank you, man. Did you get one? You guys good in the back, you both have? No? We got at least 1 or 2 extras here, don't we? Somebody? Really? Okay.
I've got a couple of extra sheets on mine. If you want to take them away, that's fine.
No, I thought I had more than enough copies, obviously not. Okay, folks, good luck with the exam, same as before. Write your answer in the space provided. Skip one question, but put a big X through it, the one you don't like. And
We just answer them all and then you X out the one you don't like?
put X through all of them, is that what you said?
I said we answer them all and you X out the one you don't like?
Me pick the one for you? Okay. Seriously, if you want to answer them all and then decide which one you think is your weakest, do it. You don't have to leave one blank, but you have to X one out. Okay, I want you to have 1 hour and 15 minutes. And that would be what? That would be, let's say 20 minutes of 5. If you're not finished by 20 minutes of 5, I'll be collecting the paper. Good luck.